I'm Molly Stevens, and I'm a partner in the Los Angeles office of Quinn Emanuel. My practice focuses on financial litigation and corporate governance litigation. In this video, we'll discuss fiduciary duties, particularly the duties that are owed when running a corporation. If you or your clients are officers or directors of a corporation or majority shareholders in a corporation, you should be aware of fiduciary duties. Although we'll discuss fiduciary duties generally, the specific law that governs what duties are owed and when there is a breach of duty depends on where the company is incorporated. A company can be incorporated in any state, and the Internal Affairs Doctrine provides that the law of the state of incorporation governs the relationship among the company, its management, and its shareholders. This encompasses fiduciary duties owed by management or shareholders. Because of the Internal Affairs Doctrine, the state where a company chooses to incorporate is a strategic decision. Most companies choose to incorporate in Delaware, but there are distinctions in fiduciary duty law across states that could affect where to incorporate. For example, Nevada has adopted laws imposing very lenient duties on officers and directors in an effort to attract more companies to incorporate there. Under Nevada's Corporations Code, directors and officers are liable for breach of fiduciary duty only if their actions involved intentional misconduct, fraud, or a knowing violation of law. In general, who owes fiduciary duties? In every state, directors of a corporation owe fiduciary duties to the corporation and its shareholders. Similarly, officers of a corporation owe fiduciary duties to the corporation and its shareholders. Finally, under certain states' laws, majority or controlling shareholders may owe fiduciary duties to minority shareholders. So what are the duties that are owed? In general, this is referred to as the triad of fiduciary duties, or the duties of care, loyalty, and good faith. The duty of care requires a director or officer to act in a careful, informed way as a reasonably prudent person would. An example is if a director is approving a transaction for the company, such as an acquisition, a credit facility, or a dividend. The director has to review and consider information relevant to the transaction, ask questions, and generally exercise informed judgment in improving the transaction. The director can't simply rubber stamp a transaction. The duty of loyalty requires a director or officer, or even a majority shareholder, to act in the best interest of the corporation and its stockholders, and not to put any personal interest ahead of those interests. For example, the duty of loyalty is implicated when a person sits on both sides of a transaction or will obtain a personal benefit from a transaction. The duty of good faith is sometimes recognized as a separate duty, as it is under Delaware law, or it's incorporated into the two prior duties we discussed. It requires an intentional dereliction of duty or a conscious disregard of one's responsibilities. Now that we've discussed the fiduciary duties, let's ask, how are they enforced? As discussed, duties are owed to a corporation and its shareholders, so the corporation or a shareholder can sue for breach of fiduciary duty. There are two types of suits: direct actions and derivative actions. Direct actions occur when the corporation itself brings a suit for breach of fiduciary duty, or when a shareholder brings a suit for harm that affects only that shareholder and not the corporation or its entire body of shareholders. Thus, a suit that a minority shareholder has been harmed is a direct suit because different bodies of shareholders, the minority versus the majority, have been affected differently. But a suit that directors approved a bad investment for the company is not a direct suit because that bad investment affects the company and the entire body of shareholders equally by decreasing the value of the company for all. So that suit can be brought as a derivative action by a shareholder. A shareholder can bring a derivative action for breach of fiduciary duty when the conduct of a director or officer harms the corporation or the entire body of shareholders. What that means is that the shareholder asserts claims on behalf of the company, and recovery will go to the company for the benefit of all shareholders equally. Now, when I represent shareholders, I always try to find direct claims if I can, because derivative claims require more procedural requirements. For example, One requirement is that a shareholder, before bringing a derivative suit, make a demand on the corporation before the suit is filed. If a company receives a demand, it should always appoint a special litigation committee or a subset of disinterested directors to investigate the allegations in the demand to determine if a lawsuit is in the best interest of the company. If the company itself determines that the lawsuit is not in its best interest, that is a complete defense to a subsequent derivative action by the shareholder. As a result, most shareholders don't make a demand on the board and instead allege in the complaint that demand would be futile. This is known as demand futility, and a shareholder only has to allege that the board could not have exercised independent and disinterested business judgment in evaluating the demand. Another requirement for derivative actions is that the shareholder plaintiff own shares in the company. Some states allow a person to bring a derivative suit as long as he or she held the shares at the time of the wrongdoing. Others require that the shareholder own the stock both at the time of the wrongdoing and continuously throughout the lawsuit and its resolution. This is referred to as a continuous ownership requirement and actually can be a limitation. Now, do these duties or enforcement principles ever change? The answer is yes, and there are two primary situations. The first is when the company is in the zone of insolvency. At that point, creditors can step into the shoes of shareholders in enforcing breaches of fiduciary duty. The idea is that when a company is insolvent, creditors have more of a stake in protecting the value of the company than shareholders do. Some people talk about duty shifting to creditors, but states generally don't recognize a fiduciary duty owed directly to creditors. Instead, creditors can enforce the fiduciary duties owed to the corporation and its shareholders. The second situation is when the company is for sale. In that situation, the directors have a duty to make a reasonable effort to obtain the highest value for the company. Now, what can officers or directors do to protect themselves for breaches of fiduciary duty? As discussed previously, a company can make sure to consider any shareholder demand made on the board in good faith, with due care, and using only disinterested directors. If there are no disinterested directors, the company can appoint a special litigation committee. If these directors determine that the lawsuit is not in the best interest of the corporation, it's very difficult for a shareholder to then maintain the lawsuit derivatively. This rule is an example of the business judgment rule. Under the business judgment rule, a court won't second-guess the decision of a company if the decision was made on an informed basis, in good faith, and in the honest belief that the action taken was in the best interests of the company. The business judgment rule will protect not only decisions made in response to a shareholder demand, but also any other corporate decisions of a director or officer. A corporation also has the ability to eliminate liability for breaches of certain fiduciary duties. We discussed previously that Nevada law imposes liability only for intentional misconduct, fraud, or knowing violation of law, which excludes breaches of care altogether. Other states require the elimination of liability to appear in the Articles of Incorporation. A company would do this by including what is known as an exculpatory clause in the Articles of Incorporation. Another way to protect officers or directors is to provide for rights of indemnification and advancement in the bylaws. Indemnification means that the company will pay any loss arising from a lawsuit and is typically requested after final settlement or judgment on the suit. Advancement means that the company will pay the legal fees of a director or officer as the suit is ongoing, and the director or officer has to agree to pay back the advance fees if it's ultimately determined that they're not entitled to indemnification or advancement. These should both be in the bylaws. I have at times seen only indemnification in bylaws, which can make it difficult for directors and officers to obtain early payment of fees via the separate right of advancement. Now, today we have discussed fiduciary duties in the corporate setting. What happens when the entity is another type of organizational structure, such as a limited liability company or a limited partnership? That's a topic for another day, but the principles we've discussed generally remain the same, although there will be fewer default duties. The idea for these types of entities is that the parties draft more fulsome operating agreements or partnership agreements defining the rights and obligations of management and owners. As a result, there's more freedom with these entities to eliminate fiduciary duties altogether. Owners in these entities should read the operating agreement and partnership agreement carefully to know what duties managers owe. Again, my name is Molly Stevens, and I've appreciated the time to speak with you about fiduciary duties. If you have any questions, please do not hesitate to contact me. In addition, also please review the website for our firm at quinnemanuel.com and be on the lookout for further videos.